Nowadays, we take it for granted that every single person in the United States has the right to purchase and carry a gun. In the majority of US states, there is no permit required to buy a handgun or a semi-automatic long gun. If you have the money, it's about as easy as buying a piece of furniture. Now, in other countries, this is not the case, because in the United States, this is due to the first 10 amendments to our Constitution, the Bill of Rights. In the Bill of Rights, we enumerated, among other things, the right to free speech, free exercise of religion, and the right to a public jury trial if accused of a crime. It is within the Bill of Rights that we find what we're concerned with here today, the Second Amendment. The Second Amendment states, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. The first half consists of the dependent clause, or alternately the prefatory clause, whereas the second half is the consequence or the operative clause. We'll see why that distinction is important later. Let's start with the first half. A well-regulated militia being necessary to the security of a free state. This is a bit confusing. Everybody knows that a country needs an army, so what's the point here? To shed a bit more light on what this means, let's take a look at what this could have been. A proposed version taken from the Virginia Ratifying Convention of 1788. That the people have a right to keep and bear arms. That a well-regulated militia, composed of the body of the people trained to arms, is the proper, natural, and safe defense of a free state. That standing armies, in time of peace, are dangerous to liberty, and therefore ought to be avoided, as far as the circumstances and protection of the community will admit. And that in all cases, the military should be under strict subordination to, and governed by, the civil power. So a militia is rather the opposite of a professional army. It's a group of citizens who arm themselves for the common defense instead of relying upon a standing here meaning full-time professional army to do so. Because as the amendment states, that is dangerous to liberty. Well, nowadays we have a full-time military, and we don't view that as dangerous to liberty. We rightly salute our servicemen and women for choosing that career. Why would the founders deride it? The reason comes from the historical context of the time. Standing armies, like that of the British, were seen as dangerous to liberty because they had no local community ties, and because they drew their power and money from the crown alone. Further, the standing armies were seen as tending to grow and consume the state. As Hamilton writes in Federalist No. 8, in a society in need of a standing army, that being a society often at war, the continual necessity for the soldier's services enhances the importance of the soldier, and proportionably degrades the condition of the citizen. The military state becomes elevated above the civil. This led to corruption, and eventually an adversarial and tyrannical relationship with the common people on the bottom and the centralized power on the top, whether monarchy or not. So the lawmakers saw it preferable to have the military rise from the populace and then disband in the case of inutility. This is why there is that key word, free. We can see that there's a lot going on here. It's about much more than just being able to defend our country. It's about the exact manner in which we do so. This brings us to the second half. The right of the people to keep and bear arms shall not be infringed. This is fairly straightforward and warrants really just one point in greater detail. What are those words, keep and bear arms? After all, the founders had the word gun. Why wouldn't they just say purchase and carry a gun? To get a bit more understanding on this, let's look at the 1792 Militia Act, passed just 1 year after the Bill of Rights. In this Militia Act, the citizens who were enrolling in that well-regulated militia contemplated in the first half of the Second Amendment were instructed on exactly which arms they were to keep and bear. Every citizen so enrolled and notified shall, within 6 months thereafter, provide himself with a good musket or firelock, a sufficient bayonet and belt, 2 spare flints, and a knapsack, a pouch with a box therein, to contain not less than 24 cartridges, suited to the bore of his musket or firelock, each cartridge to contain a proper quantity of powder and ball, or with a good rifle, knapsack, shot pouch, and powder horn, 20 balls suited to the bore of his rifle, and 1/4 pound of powder, and shall appear so armed, accoutred, and provided when called out to exercise or into service. except that when called out on company days to exercise only, he may appear without a knapsack. This, of course, all seems extremely antiquated to us now, but maybe we could think of a modern version. Every citizen called into the common defense must procure within 6 months a pistol, a semi-automatic machine gun, a bulletproof vest and helmet, and night vision goggles, and must appear at the barracks so armed when called, except on days when no night training is envisioned, in which case the citizen may appear without the night vision goggles. Still, this appears ridiculous because nowadays we rely fully on a professional standing army for our defense. A citizen militia, which comes together and then disbands in the case of every single conflict, is nothing more than a distant historical artifact. So where does that leave us? Well, for a long time, the Supreme Court treated the Second Amendment from what we might call the originalist perspective, as an obsolete provision that no longer held relevance due to the absence of a citizen militia. In 1939, for example, the court was presented with the case of United States versus Miller, in which an Arkansas man challenged a U.S. law that strictly regulated the transfer of short-barrel shotguns and rifles. The unanimous opinion of the court read as follows. In the absence of any evidence tending to show that possession or use of a shotgun having a barrel of less than 18 inches in length at this time has some reasonable relationship in the preservation or efficiency of a well-regulated militia, we cannot say that the Second Amendment guarantees the right to keep and bear such an instrument. The court thus ruled that the Second Amendment protects the purchase and possession of firearms only if it has some reasonable relationship to participation in a citizen militia. There is one subtle but important change here. The words keep and bear arms are used slightly differently than they were in the original amendment. Now they're more akin to just have, rather than some more formal military significance. Now, the tides of jurisprudence have since changed, and in 2008, the Supreme Court was faced with the case of D.C. versus Heller, in which a Washington, D.C. statute, which effectively banned the purchase of handguns, was challenged. Justice Scalia, in delivering the opinion of a court in a narrow 5-4 decision, stated as follows. The Second Amendment is naturally divided into two parts, its prefatory clause and its operative clause. Let's stop right there. Remember at the beginning of this video when we talked about how that word prefatory is very important? The first half consists of the dependent clause, or alternately the prefatory clause, whereas the second half is the consequence or the operative clause. We'll see why that distinction is important later. This is why. In using the word prefatory and then calling the second half of the amendment the operative clause, Justice Scalia effectively states that this is not, as the court had ruled in 1939, a dependent clause followed by a consequence, but rather a preface and then a pronouncement. The court goes on. The former does not limit the latter grammatically, but rather announces a purpose. This is a massive statement. In essence, the court rules that the first half of a one-sentence amendment announces a purpose, but for legal purposes, might as well not exist. This is where well-meaning citizens can disagree, because the meanings of words and laws with them change. While the original intent of the Second Amendment may have been to prevent the federal government from disarming the citizen militia and instituting a standing army, there still is a strong current of individual sovereignty that underlies the Bill of Rights. If we are going to emphasize that and embrace a much more broad-based interpretation of the Second Amendment, we must be honest, as we are in other areas of law like the extension of the Commerce Clause, that we are taking the law past its original intention and embracing a new, distinct, and modern interpretation. In sum, from an originalist perspective, it's clear that the founders viewed the right to keep and bear arms as inextricably linked to participation in a citizen militia which was at odds with the prospect of a standing army. However, if guns are important to your culture and life, it seems unfair that the second half of that clause, which rings so loud and clear, would be completely nullified just because of the first half's obsolescence. So that's where we are. Laws change and opinions differ, but as citizens, we all have the right to understand where our laws come from and how they're interpreted. If you'd like to dig a little bit more into this, I put some resources in the description. And if you'd like to see more content like this, please like this video and subscribe to my channel. See you next time.